Ladies and gentlemen, as announced by the Bartek, by the panel leader, my name is Marcin Wielec. I came from Poland, and I have a great honor to represent at today's conference my Cardinal Stefan Wyszyński University in Warsaw, specifically the Department of Criminal Procedure. Thank you very much for inviting me here to this wonderful international event, wonderful international conference. As we all know, it's an annual international scientific conference devoted to broadly understood legal issues dedicated to children. But this year, as it has been noticed at the beginning of our conference, the jubilee of the Convention of the Right of the Child. For me and our delegation from Poland, the fact that we speak about and celebrate the entry into the force of the Convention of the Protection of the Rights of the Child is great, very great distinction, because it's worth recalling that work of this convention was initiated mainly by Poland. Here great importance and great admiration finds the legal work of the Polish scientific community in the people of Professor Tadeusz Smyczyński and also Professor Marek Andrzejewski. Professor Marek Andrzejewski is among us. But ladies and gentlemen, going back deeper to Poland history, let me mention one more pioneer in the field of child right protection, the creator of special pedagogy, elements of psychology for the child, or even more broadly on social policy dedicated to children. So I'm speaking about Janusz Korczak, an outstanding educator and defender of the rights of the child, murdered by the Germans during the Second World War in Treblinka German death camp. Polish Janusz Korczak very clearly emphasized the need to listen to the child and treat him with full respect as well as protection against psychological violence that may occur in such a situation. So, ladies and gentlemen, there are the personal foundations of the current legal status as far as the system of children's rights is concerned. Without the contribution of these people, there would not be what we have today, about which we are discussing here. Let us be grateful for them. Therefore, let's come back from the past to the present. So, therefore, first what we need is to realize what emotion accompany the child in the center of legal influence. Preparing of this speech, I reminded myself with a book that I loved when I was a little boy, but which gave me a lot of thought, a lot of true wisdom. This is Oliver Twist by Charles Dickens. Sitting this book, there is such dramatic scene as a little Oliver, after a dramatic running, accused of fictional robbery, is arrested and just stand before the judge. He is not guilty, but nevertheless found himself in a place completely alien to him, where sometimes innocent can lose to guilt. Oliver Twist is not treated as a child who needs a support, love, understanding by a judge, but this judge views him as a criminal who deserves only the punishment. Oliver in this scene is trembling. We feel like he has no idea what to say. His voice is too weak to break through the walls constructed by adults with harsh rules and principles. This is precisely what a child feels during criminal proceedings, and more so during any other legal proceedings in, I'm sure, any country. The child is small, insecure, and does not fully understand what he was at the center of the often aggressive conflict. Conflict is not a suitable place for a child who requires love, not judgment. And ladies and gentlemen, our journey into the legal arena begins here with the enormous responsibility of adults. It is adults who are responsible for the quality of law, especially the law that includes the legal position of the child. Because because any involvement of the child in the conflict between adults is wrong. Any trial concerning the child are wrong. Any interference in the innocent world of the land of the child is wrong, because all of it will leave a lasting, strong, and only negative mark. And here comes the role of adults who, knowing about these weaknesses, should prepare legal regulation that are pleasant for the child. Looking at the Poland legal system, examining the legal regulations functioning in Poland concerning children, I organized them into several groups. Of course, we don't have enough time to discuss of the whole system, so I choose the most important elements and institutions. Finally, I divided them into 5 groups. The first group I call static regulations, defining basic concepts such as a concept of the child and therefore basic legal regulation, which also involves indicating the catalog of the definitions, rights, but also the obligations. So, although nowhere in Poland is there a legal definition of a child, there are several laws that contain the definition of this concept. In the first place, the concept of the child functioning in Poland, of course, indicated in the Universal International Legal Act, Convention of the Protection of the Right of the Child. National legal regulation may distinguish the concept of the child contained in the Act of the Ombudsman for Children. The Polish Act, Ombudsman for Children, specifies who should be understood as a child. In this group, legal, ladies and gentlemen, of legal regulation, here you can also include completely new legal regulation in the form of a law that provides many guarantees to children during legal proceedings in Poland. It is mainly about the so-called Lex Kamilek. Act is the common name for the amendment to the Family and Guardianship Code and some other act, of course, adopted of July 28, 2023. This law was introduced in response to the tragic death of 8-year-old Kamil from Częstochowa, who died as a result of domestic violence. Main goal is to strengthen the systemic protection of children against violence and neglect. Key changes introduced by Lex Kamilek are verification of employees in contact with children. From February 15, 2024, every institution in which work involves activities with children must comply with the rules of safe recruitment. Employers are obliged to check whether potential employees are not listed in the register of sexual offenders. 2, introducing standards for the protection of minors. From August 15, 2024, institutions working with children are required to develop and implement standards for the protection of minors. These standards are designed to ensure a secure relationship between minors and staff and set out procedures for intervention in a situation of child welfare risk. Changes in the court proceedings concerning children. The amendment introduced, among others, the possibility of a one-time hearing of the child during the proceedings, unless the child welfare requires re-examination of this activity of the child itself reports such a need. Duties for health care institution, medical facilities such as hospital, pharmacies, dental offices, are required to verify too the criminal record of staff to implement procedures to protect children from violence. And the second group consists of kinetic regulations, mainly procedural, that is, those that provide for the rules of participation of the child in legal procedure. And here you can indicate, for example, of the rules of questioning a child contained, for example, in the provisions of the Code of Criminal Procedure. The rules of the interrogation of children in Polish law are intended to ensure that the hearing is as less traumatic as possible for a minor. But, ladies and gentlemen, one more important notice. Children, in criminal procedure mainly, children who are victims or witnesses of crimes are particularly sensitive, and inappropriate treatment during interrogation can lead to the very dangerous process, a process of secondary double victimization, which will deepen traumatic experiences. So, generally speaking, the aforementioned double victimization is a phenomenon where a person who has already once been a victim of a crime, violence, or other harm experiences repeated suffering. The cause is not the original event, but rather the subsequent treatment of the environment, institutions, public services, or person who should support it. The term refers to the additional trauma victim experiences as a result of inadequate or harmful treatment by the legal system, social services, medical workers, even the family. So, let's come back to the criminal procedure. For instance, therefore, special rules apply to children, such as in only shortly version. One-time interrogation and its registration to avoid having to repeat stories about traumatic experiences, hearing in the presence of a psychologist and in friendly conditions to create an atmosphere of security, prohibition of contact with the accused to protect the child from additional stress. And the third group is the substantive provisions of mainly are the provisions, of course, of the Polish Criminal Code, which contains a number of crimes that can be committed to the determined of the child. There are a few crimes, of course, here. An example, because there are many of them, there will be, among others, of course, a crime under the Article 200 of the Criminal Code, and two of a crime of sexual abuse of a minor or a crime of pedophilia. And the fourth group, organizational regulations, is devoted to the institutional system. In this system created from public entities intended to protect the rights of the child. On the front line of this system are public bodies, of course, but on the highest rank because they are constitutional bodies. Both the Ombudsman and the Ombudsman for Children, their foundations of functioning in the legal system in Poland, first of all, derive from the highest ranking provision I mentioned, that is the Constitution of the Republic of Poland. And the fifth groups consist of the public law administrative regulation in Poland, devoted to the general issue that are related to the functioning of society in Poland and indirectly also affect the position and protection of children's rights. It is, among other things, the establishment of State Commission for the Prevention of Sexual Abuse of Minors under 15 years, and the entire, of course, general system of social protection. The aforementioned Commission for Pedophilia, we called, is intended to explain cases and actions directed against sexual freedom and decency against a minor under 15 years of age. Basically, these are, in overall, all regulations that operate in Poland in the service of protecting the child welfare. But let me say, finally, one more mark, because very serious something of psychological elements are connected with child activities and protect in law area. It is important to remember that even though a children is neutral, natural, and good by definition, it can still be used by adults as an aggressive, dangerous, and negative tool without realizing of this. In the past, I dealt with the issue of child abuse in civil proceedings, such as divorce cases, by starting parallel and full fictitious, criminal proceedings against one of the parents, especially when it involved pedophilia. Jan Banowski from Poland mentioned about this, but I want to notice about it as a strange, dangerous phenomenon, is especially links in the criminal proceedings. Maybe it is not syndrome, maybe it is a strategy. Parental alienation syndrome, PAS, is a term that describes a phenomenon in which one parent, most often during a divorce or separation, deliberately and systematically manipulates a child to move them away from the other parent, causing negative feelings and attitudes towards the other parent in the child. Parental alienation is a process with, very shortly, with a lot of controversial matters, with a lot of elements in which one parent tries to program the child to feel resentment, fear, or hostility towards the other parent, often through false accusations, negative opinions, and emotional manipulations. Basic features of parental alienation syndrome can be distinguished such as manipulation of the child by one of the parents, creating a negative image of the second parent, child attitude change completely, refusal to contact the second parent. And the question comes back. All this here, very strong PAS, something connect with criminal proceedings. Maybe it is way to lead a strategy, not a syndrome. To sum up, To sum up, participation of a child in a legal procedure in a process that require special attention and care, because the child is a very sensitive person with limited possibilities of understanding and dealing with the difficulties of the legal system. And at the end, and let it be as our great and lovely Pope John Paul II said during the pilgrims to Poland in 1991, let every child we find in adults defenders of their dignity and rights. Thank you very much for your kind attention.